Hello, everyone, and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Thank you, Mona. Good day and a warm welcome to all our attendees around the world. Today's topic is data center disputes with a focus on delays, defects, and damages. My name is Stuart Blessing. I'm a chartered electrical engineer with 25 years experience in a range of industries, including power generation, electrical distribution, building services, and critical infrastructure projects. I'm a technical expert witness and have testified in international and domestic arbitrations in Dubai, London, Singapore, India, and Canada. I'm pleased to be joined today by two great panelists, Anna Mills, partner at DLA Piper, and Peter Brogden, a barrister at Keating Chambers. Anna is a global co-chair of DLA Piper's international arbitration practice and is focused on construction and engineering disputes for over 20 years. She acts for a wide range of domestic and international clients across a number of different industry sectors, including renewables, specifically wind, conventional power, infrastructure, oil and gas, transport, and manufacturing. Anna is also involved in various data center disputes. Peter is an experienced construction barrister with principal specialities in construction, energy, shipbuilding, and technology disputes. For the past 18 years, he has worked on a range of engineering disputes, including power stations, pipelines, oil and gas facilities, biomass, and civil infrastructure projects. His work includes arbitrations seated around the world, including Australia, Korea, Hong Kong, Singapore, and South Africa. Peter's also a former software engineer and sits in the Bar Council's Information Technology Panel, which advises barristers and government departments on security, data management, GDPR, and emerging technologies. Thank you both to Anna and Peter for joining us today. As digital infrastructure continues to underpin global economic growth, the data center sector remains at the forefront of this transformation. With the exponential rise of AI, cloud services, and data generation, the demand for scalable, high-performance data centers is accelerating at an unprecedented rate, and governments around the world are beginning to designate data centers as critical national infrastructure. The growth of the data center market gives rise to disputes related to both the construction and operation of these facilities. We'll start today's discussion with some questions to Anna, focusing on the issues and potential mitigation measures from an owner-operator's perspective. Then Peter will speak to the principal causes of disputes and how to avoid them from a contractor's perspective. And lastly, at the end, we'll have a Q&A session, which will be time dependent on how much time we've got left. And just a note that the questions posted online will be anonymous. However, if you feel comfortable, please feel free to leave your name and organisation such that we can respond accordingly. But before we do that, I'd like to introduce a poll asking two questions, and I'll ask all participants to answer the following questions. So the first question we have is, how familiar are you with the legal risks associated with data centers? And you get three options there. And the second question we have is, have you or your clients ever faced a legal issue related to data centers? So if you wouldn't mind just spending a few seconds answering those poll questions, and then we can share the results once complete. hopefully that's given us enough time for everyone to input into the poll. So as we can see here, the answers to the first question, majority of attendees are somewhat familiar with 60%. Second would be not familiar at all at 31%, and lastly, very familiar at 9%. And the second question, have you or your clients faced legal issues related to data centers? And again, the second question, yes, a few is 44%, no is the top one at 46%, and yes, a few closely behind 44%. And lastly, at 9%, yes, many. So thank you all for that. Anna or Peter, do you have any comments on the poll?
Only to say that it looks like we'll be speaking to an audience that isn't completely unfamiliar in most cases with the issues at hand, which is helpful. So I hope that also means that we'll get some exciting questions posed in the Q&A, but no pressure.
Thank you. Okay, moving on to the first question then. Anna, we often hear about disconnects between tenancy agreements and development agreements or construction contracts. What risks do owner-operators face when those documents are not properly aligned, particularly around third-party rights?
Stuart, if perhaps we could share the slide that's being prepared, because I'm conscious that when we're talking about data center disputes, there's usually a very complex contractual matrix that sits behind those disputes. And for those who ticked not very familiar with the way that data centers work, I think it'll be helpful just to have this slide up while I'm talking so that it can be used as a bit of a check for context and to place the parties that I'm going to be discussing. Because I think one of the most significant issues that I've seen is the disconnect between the tenancy agreements with hyperscalers and the development agreement between owner-operator and developer, and the third-party right that often exists between owner-operator and the professional team. So if you just, for the audience, if you're looking at that matrix, you'll be able to find those parties identified in the various different boxes. And part of the reason is that the tenants have a lot of influence and bargaining power. And the tenancy agreements will usually, often they're bespoke, and they will usually provide for very significant liquidated damages for example, delay to access. There'll be service level damages, rent credits, there might be consequential damages for lost profits or for business interruption, and very onerous termination rights that can be triggered more readily than you might otherwise see in typical commercial contracts or other construction-related contracts. And the risk that the owner-operator has to handle on these projects is the recoverability of those losses that may be suffered down the line, up the line from the developer superior landlord in the dark orange box on the slide, or indeed from the professional team under the third-party rights notices that may exist, and also with an eye on ensuring that there's adequate insurance as well to cover the professional team. Because Peter will discuss shortly that data center builds are construction projects, and therefore the types of claims that you'll experience on any build, you will also see or may also arise on data center projects. But the nature of data centers once they're operational means that defect claims in particular can be really problematic. And liability in these circumstances can also be very problematic. And that's because often where defects are detected late in the day, often after the expiry of the relevant warranty period, the developer, again looking at the dark orange box on the slide, will not have any liability because that liability will have expired on the issue of the notice of making good defects or a similar notice depending on which contract form is being used. And in those circumstances, the owner-operator will only have third-party rights against the professional team. And those third-party rights that it has may be more limited than the rights that the owner-operator would have had against the developer, and indeed more limited than the developer may have had against the construction contractor, so the main contractor, that's the party that you see in the red box on the slide. Plus, in many cases, as owner-operator, when you're looking at third-party rights, you may actually have to pursue more than one party at a time. What you will rarely see, and again, this is based on my experience, but on a number of different data center disputes, is alignment between the losses that may be suffered in the tenancy agreements and the losses that owner-operator can recover up the line. And people will often say, well, that's market, tough luck, there's nothing you can do. And there may be some truth in that, there often is. But I think oftentimes it just isn't considered carefully enough at the point of contracting or in the detail that one looks at these things when something goes wrong. So from my perspective, third-party rights notices need to be drafted very carefully indeed to make sure that they don't unnecessarily limit the ability of the owner-operator to recover what may be very significant losses that they're suffering down the line.
Thanks, Anna. Next question I have for you is, from your experience, the structural defects in a data center, such as a slab deflection or a vibration, translate into commercial consequences for owner-operators?
So I think structural defects are the nemesis of a data center owner-operator. They can have outsized operational, financial, and legal consequences. We hear a lot, and I personally have been involved in many disputes involving, for example, the cooling systems for data centers, the power supply for data centers, fit-out issues, delays, etc. But structural defects tend to have much more serious consequences, and particularly, as I alluded to a moment ago, if those defects are identified late in the day. They pose a risk to the critical infrastructure that's within the data center. They can pose a risk to human life. They can cause downtime. They can pose regulatory issues and breaches. And practically, they're complex, expensive, and slow to resolve. So first, like any defects case, there's an investigation. And investigating structural defects in a live data center is fiendishly difficult. I don't know how many people who are listening today have actually visited a data center, but you can take it from me that getting in is more difficult than getting into Fort Knox. There are obviously real data security issues that have to be grappled with, and permissions are required from tenants, but the result is that it's extremely time-consuming and laborious. Second, data centers are clean environments, so they are designed to minimize dust, pollutants, vibrations. So performing any work at all, even just at the investigation stage, is incredibly challenging inside a data hall. Sometimes you get lucky and you might be able to perform the works that you need to perform from outside of the data halls. But often you actually need to be doing it where the racks are and where the information is kept, and that is very, very difficult. Third, assuming on investigation you do find that there are some structural issues that need resolving, then performing substantial remedial works is even more challenging. And often you might be looking at a decant, recant scenario where you're actually trying to move a tenant out of a data hall into another data hall that you will have to build and set up, and then move that tenant back into the original data hall when the works have been performed. And of course, that assumes that your tenant isn't just going to terminate the tenancy agreement when it learns that there are structural issues that make that data hall, that data center, unsound. And all of this, of course, has to be balanced against the owner-operator's health and safety obligations, and the need in some cases to move as quickly as possible. But then aside from the practical issues and difficulties, you then have the recoverability issues that I outlined a moment ago. And this sort of claim does not come cheap. So you're looking at many, many, many millions in losses. And so the consequences are huge. And of course, it would be remiss of me not to mention discussing this, not just the financial losses, but the reputational risks that exist here for owner-operator, and also the potential damage to the commercial relationships that they have with their tenants. most of these projects, or most owner-operators, don't only have one data center. And the ongoing relationship between the tenants, and particularly hyperscalers, is of real commercial significance. Finally, I think that one of the other problems that owner-operators will face, and perhaps this is becoming an increasing problem as the market develops and changes rapidly, is how to measure the loss that they have suffered or will suffer. So if a structural defect manifests that needs remediation, but perhaps it doesn't pose a health and safety risk, and therefore there may be a period of time available before that problem has to be remedied, then I think it's very difficult for the owner-operator to assess the diminution in value of the asset, or indeed the loss that it might suffer, in circumstances where requirements for data centers, whether that's the power loading, the structural loading, or whatever it might be, are changing. And then it's very difficult to assess what the requirements might be at the point at which you need to carry out the works.
Yeah, I think, Anna, and I think it's quite obvious if the issue is a major issue and the impact it can have. But I think, is it fair to say that even in minor construction issues can then escalate into major legal, commercial, and reputational exposures as well?
Absolutely. And I think that's why, for the purposes of answering this question, it's a more interesting webinar, I think, for people to listen to, is the real issue is once your data center is live. Once your data center is live, even the smallest problem is going to cause major operational and legal consequences. And the costs just increase so rapidly, partly due to the losses that are going to be suffered, but partly due to the practical considerations that you have to look at if you're going to resolve that issue.
Yeah, thanks, Anna. Next question we have is, taking a step back, do you think current contract structures adequately reflect the operational realities and risks of running a live data centers, or are owner-operators still too exposed?
Look, I think it's important to start with recognizing that not all contracts are the same. So even the slide that we've got on the screen now, I'm sure there'll be plenty of people in the audience thinking, well, I've seen different things, it doesn't always look like that. And that's absolutely right. It doesn't. There isn't a one size fits all. And the terms of the relevant suite of contracts and how those contracts interact with one another will depend very heavily on the parties involved, their bargaining power, the commercial relationship between them, the lawyers used to negotiate the terms, the specific projects and the requirements of the data centers, and many, many other factors. So we mustn't generalize, and undoubtedly there will be some out there that do adequately protect the owner-operators. So if there are any nervous owner-operators listening today, don't panic. It's not all bad news and doom and gloom. But having said that, I am now going to generalize, by reference to my own experience at least, and say that in the disputes I've worked on in the last 15 years in this space, and I'm sticking my head above the parapet a little bit, I do think that owner-operators are still too exposed. And I think that the real area of vulnerability concerns the alignment that I've talked about, or the misalignment, whichever way you want to look at it, between tenancy agreements and development agreements and third-party rights, particularly concerning serious defects that are detected later in the day. And I think what we see at the moment is that there is a huge amount of demand, and that the hyperscalers, the big players in the market, are the big gorillas. And therefore, there's a sense that there isn't necessarily much to be done for the time being in terms of negotiating more owner-operator friendly terms in the tenancy agreements. Although, of course, one should always do their best to get the best terms that they can. But I think there can be more effort and more focus on aligning the terms in the tenancy agreements with the terms in the development agreements and third-party rights to try to ensure a pass-through scenario, or at least being aware of the challenges that you might face further down the line if you have a dispute and if your suite of contracts is not aligned, so that it doesn't come as a very expensive surprise. And due attention also does need to be given to the insurance position, both for the insurance relating to the professional teams and also indeed the owner-operator. And probably final observation I would say is that also have an eye on the assignment abilities under the construction contract, whether or not it's possible to assign that building contract to owner-operator or indeed to any forward purchaser without consent in due course.
Thanks, Anna. I think one variable as well to add in there would be, quite importantly, would be the country or the jurisdiction in which the data center is to be constructed. That would be a huge variable across the world with contract form.
Absolutely. And you do see that. I mean, I have an international dispute at the moment relating to a data center, and certainly there are different considerations relating to that project, from example, to the domestic projects that I'm involved in.
Yeah. Okay, thank you very much. That was very helpful and insightful. We'll move on to Peter now. Peter, more of a general question for you, and I believe you're going to take us through a presentation, but the question I've got for you is could you give us some insight into the principal causes of disputes and how to avoid them from a contractor's perspective?
Absolutely, and thank you, Stuart, and good afternoon to colleagues joining this webinar. As Stuart mentioned at the outset, my name is Peter Brogden. I'm a barrister at Keating Chambers, and I've been representing employers and contractors for about 18 years now for my sins. But just as Anna was speaking very helpfully and interestingly about the perspective of the owner-operator, I'm going to try and address Stuart's question about the common causes of disputes from a contractor's perspective, and what a contractor might be able to do to ameliorate or reduce the prospect of those disputes. I hope it's also interesting from the perspective of an owner-operator or a subcontractor, because I think knowing and understanding how these disputes arise is quite important in avoiding them. And in order to do that, as Stuart mentioned, I'm just going to share my screen, so hopefully this will work. And these, if everyone can see my screen, you'll see just on the left of the screen, I've put together 6 categories of common causes of contractor disputes. And on the right of the screen, I was going to give you some examples as to how those things might arise and what one can do to deal with them. The first one, and I think in my experience, the largest issue with construction projects to build data centers and more general civil infrastructure is delay. And just before I get into that, it's probably worth just explaining what I mean by contractor in this context, because what you'll often have is a owner-operator will engage a contractor, which will often divide the works into 2 phases. You might have a shell and core, sometimes called a base build contractor, which will build the shell of the building and some of the more basic electrical connections. Then you'll have a fit-out contractor in the context of a data center. They will be the party installing the more detailed and complex electrical systems, cooling systems, lighting, control, building management, and the like. And then once that is done, you will then have the owner-operator will install, and practice varies here, but will usually be responsible for the computer hardware, essentially the servers and the racks and such like. And then the tenant will sometimes install its own hardware into the racks and operate the data center infrastructure that way. So what I'm trying to focus on here is, when I say contractor, really the shell core, base build contractors and the fit out contractors. And in terms of delay, there are, I've put out 7 examples there on the right. You'll often get, as a cause of delay, supply chain disruption for specialized equipment, so transformers, generators, and the like. And just if I flick away from this for a moment to show you a survey that was recently conducted by Turner and Townsend, a fairly well-known quantity surveying outfit. And they asked their contractor clients and industry participants, what has the average percentage change in data center construction tender bid prices been in your region in the past 12 months? And how much has it increased? And you'll see really about 3/4 is over 5%, so exceeding inflation in most parts of the world. And in about 1/3 of cases, more than 15% positive rise in the data center construction tender bid prices. And that increase can be a cause of financial risk to contractors, particularly if they're reliant on suppliers for providing important critical equipment. And the pie chart on the right there asks the same participants what percentage change they anticipate within the next 6 months. And again, you can see about 2/3 there anticipate an above inflation rise and about 20% are anticipating that component costs will go up by at least 15%. So that's really significant, because obviously it's usually for the contractor to procure this equipment and price that into their bid. And if they haven't adequately priced, then that can lead to a potentially loss-making contract or attempts to pass those price rises on to the employers. Now, I know that most shell and core or fit-out contractors aren't concerned with the cost of chips, because that would normally be for the owner-operator or the tenant. But I think for this type of equipment, the price and production rate of integrated circuits, so essentially semiconductor chips, can be a useful proxy for the availability of production of this kind of equipment. And you'll see from this graph, which plots the availability and in unit shipments of integrated circuits back from 1990 through to just the post-pandemic period. And I think this is quite topical, because of course it shows how various world events create problems with the supply chain. So here we've got obviously the Asia crisis, the dot-com bubble, the Japanese tsunami, the subprime crisis in 2008, ironically, the trade war, a very brief dip in 2019, COVID-19 pandemic created a big chip shortage. And of course, one can imagine, I couldn't find a more recent line graph, but I imagine if one were to extend that to 2025, 2026, one would very quickly see the effects of global slowdown given Mr. Trump's tariffs, particularly when the vast majority of chips in the world are made in Taiwan, and that's recently been hit with a 40% Trump tariff. Although there's been an exception recently that may or may not apply. So the point of those slides was really just to illustrate how supply chain disruptions can be a source of delay. And that is essentially the second bullet point as well. There can be very long lead times for critical components. Volatility in material supply and costs. You can then have unforeseen site conditions, which can be anything. Usually it will be ground conditions, and things like that, but you might find archaeological discoveries in the ground where you want to build your data center. That sort of thing can cause delays and disruption. You'll then have client-driven changes and scope creep, and I'll come on to that in the fourth section on scope changes. And there can be problems with the availability of skilled workforce, planning and permit delays, particularly when it comes to power, load, peaks and spikes, water for cooling and things like that. So they can all create delays, particularly when you're looking to someone else who you may not control, like a government regulator, to provide those permits promptly. I've certainly had problems, particularly in the Middle East, with power connections delaying the start of civil infrastructure works, the commissioning phase or things like that. So one needs to be aware of who bears the risk of these sorts of delays. Contractors also face issues with disruption, which is often regarded as the poor cousin of delay. It's certainly less sexy, but it's just as important, because whereas delay looks to compensate the contractor for time-related costs, so essentially costs which scale with the amount of time the project lasts, so things like site security, welfare, canteens, accommodation. So disruption serves to compensate the contractor for things that increase task-related costs, like materials, labor, and plant, which can be equally, if not more important than time-related costs. And there are many things that can cause disruption in the context of a data center. Late or out of sequence access is probably the biggest one that I see in my practice. So for example, you'll have a base build contractor constructing parts of the containment building for the data center, and they may be running late. And the owner operator may say, well, look, we see you're running late, but perhaps we can resequence to get the fit out contractor in to the bits that you finished first so that they can get working. But of course, the fit out contractor might say, well, in my contract program, in my work profile, I plan to have access to this part first, and you're giving me access to that part. And that's not very helpful, because now I have to work in a suboptimal way. And that's going to mean disruption, more workers, and of course, more costs in order to meet the contractual deadlines. And again, change of scope in client instructions can cause disruption, coordination failures by poor project management, restricted working conditions. So perhaps a government regulation is introduced that means that workers can't work more than a certain number of hours in a particular day. I've certainly seen that in the Middle East, where temperatures can rise above a certain level and work has to stop, and no one can help that. Seasonal changes like Ramadan in the Middle East, or Easter or Christmas holidays in European countries can often create disruption, because where a delay might push work into a less productive period, like the peak of summer, the peak of winter, or Easter, Christmas, Ramadan, that can then cause disruption because workers can't work for as long hours. And there can be other sources of disruption as well. Payment issues also cause contractor disputes, often in the context of data centers, but also wider infrastructure projects as well. And I've listed here a few of the payment issues that often plague my practice. So disputes over the valuation of variations of changes of work scope. Often that can cause work to stop if a variation can't be agreed because the employer wants it, the contractor has a certain price for it or doesn't want to do it because it will interrupt the rest of their work. And there's then a dispute over the valuation of that, which can have the potential to stop work. There can be disputes over whether a milestone is met, payment disputes when defects are found. The employer might withhold money because they believe they have the right to do so for delays or disruption, and that will affect the contractor's cash flow, so they can't then pay subcontractors. Subcontractors will walk off site, and then you have delays caused by payment issues. And of course, insolvency events can be a common cause there. One of the most interesting in the context of data centers is scope changes. And I think this is really important because when one is building a basic warehouse or a school or a hospital, the end result, the end goal of that thing that you're building is fairly predictable. So you know there are going to be kids being educated, patients recovering. You sort of know what the world is going to look like for those projects in 5 or 6 years' time. Not so with data centers, because of the pace that technology is changing. I mean, if you were to ask me 6, 7 years ago, what would be the dominant use of a modern data center these days, I wouldn't have said TPUs, tensor processing units, which are the type of processing infrastructure used to carry out machine learning transactions or large language model training. I wouldn't have said that, principally because TPUs didn't exist 6, 7 years ago. But 6, 7 years ago is when the data centers that are coming online now were commissioned back then. If you'd asked me 6 or 7 years ago, I would probably have said storage, long-term storage, vast storage. That was certainly Amazon and Azure's focus 6 or 7 years ago. But now it's machine learning. That's where the money is to be made, and that's where there's a technology arms race. So there are scope changes because the power and infrastructure requirements for a TPU are different from a GPU to a CPU, and there's less need for the amount of fast RAM that you might have required 5 or 6 years ago. So the nature changes, and that means that there's often scope changes in these contracts midway through. So there have to be adaptations made that then can cause delay and disruption. Then a large part of my practice is spent dealing with quality and defect issues, substandard workmanship, deleterious materials or substandard materials, and issues that arise when certain aspects of the specification are not met. And here I think data centers are particularly unusual. They share commonalities with other complex infrastructure, but they differentiate themselves from ordinary infrastructure simply by virtue of their complexity. And in that context, there was a case about 8 years ago now, 2017, gosh, that makes me feel old, called MT Hogard and Eon, which some of you may be familiar with. And it's worth mentioning that in this context, I think, because it was a case not about data centers, but about wind farms. There were 60 wind turbine generators being developed in a field called the Robin Rigg Field in the Solway Firth in Scotland. And essentially there was, as you might expect for a wind farm, a horrendously complicated contract there was, I think, 25 lever arch files or thereabouts of specifications. And of course, within those specifications, there are references to standards, conventions, and regulatory documents, which also have to be followed and are thereby incorporated. And the contract contained a really interesting provision, which you sometimes see in data center contracts. And it went like this: the contractor shall, in accordance with this agreement, design, manufacture, test, deliver, and install and complete the works. So each item of plant and the works as a whole shall be fit for its purpose, as determined in accordance with the specification using good industry practice. So fit for purpose in accordance with the specification was the general requirement. But then it turned out that deep within the specification, in some schedule buried deep within the contract, there was a reference to a particular standard for marine engineering called J101, which contained a formula itself for the structural components that went into a certain part of the nacelle in the wind turbine. Now, why is this relevant? Well, it's because within that specification, buried deep within the contract, there was an error in the formula. It was simply wrong. And the contractor built to the specification in accordance with the formula, the result of which was that the foundations of these wind turbines were faulty, and it would cause essentially them to fail within or well within the design life, and that was a defect. And so we have the situation where there are two specifications, one requiring fitness for purpose and one requiring compliance with a specification which itself was wrong. And so MT Hogard, the operator, said, well, this is a defect, and Eon, the contractor in this case, said, hold on, no, it isn't. We complied with one part of the specification, and your specification was wrong. And this went all the way to the Supreme Court, and Lord Neuberger gave the leading judgment. And he essentially said, where two provisions of the section impose different or inconsistent standards or requirements, rather than concluding they're inconsistent, the correct analysis is that the more rigorous or demanding of the two standards or requirements must prevail, as the less rigorous can properly be treated as a minimum requirement. So why am I telling you this? Well, because in the context of a data center, if you have buried within your specifications reference to further industry specifications, there may be errors in that. And it is the most rigorous standard in your contract that will be held to apply. And so it's really important when you start at the outset to go through the performance spec and to have some risk allocation mechanism in your contract to prevent disputes arising when these sorts of defects are found deep within the specification. And of course, finally, particularly in the context of data centers, there may be performance guarantees which are held, to which the contractor is held. In this example, failure to meet uptime, power, or cooling requirements. And there may, as Anna has mentioned, be more serious structural issues which could take systems offline. So those are sort of very broadly 6 groups of contractor disputes. And just in my final slide, I was going to set out, sorry, this is my penultimate slide, I should just say, I forgot about this one. This is a study by HKA in the Middle East, looking at the top ranking causes of claims and disputes in major infrastructure projects. Because they're based in the Middle East, it's slightly more Middle East focused. But it shows that there is really what I would call a fairly broad spread in causes. But we have right at the top there, change in scope, which I think in the context of data centers is really important because of what I've said. The pace of technology means that scopes will change during the construction phase. And you can see in the Middle East, for example, that accounts for more than half of the disputes that contractors encounter when it comes to infrastructure projects, slightly less than the rest of the world. But you can see just by putting change in scope to one side, design incomplete, approvals being late, design incorrect, poor management are all fairly equal causes of contractor disputes. So one has to look to various sources for these kinds of things. And in what I will now say is my final slide, I was just going to set out 5 possible legal strategies for success and for avoiding these disputes. The first, balanced contract negotiation. If your contract is too unfair to the owner-operator or too unfair to the contractor, what you will find is, in the worst case, insolvency. In the best case, they might simply suspend and you'll be in dispute during the currency of your project. So by ensuring there's a fair risk allocation at the start and a clear definition of roles and responsibilities, you can start to avoid those sorts of disputes. Effective change management will hopefully go some way to dealing with the scope change points that I mentioned. So there needs to be a very, very clear procedure on how a variation is to be floated in the interim stage. So an owner-operator wants a change. Maybe they don't want it immediately. They want to understand how much it will cost. So you need a provision which will say, okay, well, it's floated with the contractor. They go away, they figure out what the time, disruptive and cost impact will be. They'll come back to the owner operator and they will then decide whether or not to proceed. And you shouldn't proceed without authorization in this very particular form. It might have to be signed by a particular person or in a particular format. And only then is it logged in a particular way and it goes forward to be constructed. All too often I see changes instructed informally, verbally, required by reason of urgency. There's been a miscommunication as to whether a change is floated or ordered for execution, and that can cause a lot of disputes. Comprehensive documentation is incredibly important, particularly when it comes to delay and disruption, because often I see contractors come to me with potential nascent delay or disruption claims, and they will say, well, I want to run a sort of global claim because I don't really have the documents, but I've suffered loss and the loss is genuine, and I genuinely believe it was because of this. But I've heard there's this thing called global claims, and I just want to do my best with the documents I've got. Now, in principle, one can run a global claim if one does one's best, but in a world where the contract says you contractor must keep records showing when instructions were ordered, what the effect of this was on your workforce, what you were doing at each time. If the contract requires you to keep records, it doesn't lie well in your mouth then to say, I'm sorry, I haven't got the records, I've breached my contract, but I want the court or the arbitrator's indulgence to bring my delay and disruption claim. So having those documentation requirements in your contract may help insulate an owner-operator from those kinds of disputes, and requiring your contractor clients to do that may ensure that their disputes can be properly prosecuted. Final 2 points, and as a lawyer, of course, I would say this: proactive dispute resolution. Having a dispute escalation clause can actually help people, rather than just marching off to lawyers when they all fall out. It can help people resolve their disputes. So it perhaps first gets set down in writing in a letter, then it goes to senior management, then it goes to mediation, then it goes to perhaps an informal DAB, and only then does it go to international arbitration with all the costs and delays associated with that. And finally, and it's a sort of form of dispute resolution, engaging talented experts like Stuart early on can be incredibly helpful. We had in chambers, we had a member of my chambers sent along to the Shard in London during the time it was being built. He was employed by Mace, the main contractor there, and essentially his job was to come down to site every Thursday without fail and talk to everyone, listen to their grievances, and give an informal, non-binding indication as to where that dispute would lead. And actually, that was incredibly effective because he was regarded as neutral, even though he was paid by Mace, and he was able to just provide these non-binding indications of his view of the dispute. And actually, as a result of that, there were no formal disputes arising out of what was then one of the largest construction projects in Europe. And the same is currently happening in the biggest construction project in Europe, Hinkley Point C in Somerset. There's proactive dispute resolution, and although there have been some disputes, most of them have been resolved fairly early on. So real proactive dispute resolution at an early stage when it comes to your data center can prevent these disputes, thereby preventing delay and disruption. Now, I'm conscious I've spoken for a very long time, so I'll hand back to Stuart to see if he's got any comments or follow-up questions on what I've said.
Thanks very much, Peter. That, again, very helpful and insightful. Just very conscious of time. We've got 15 minutes left, and at the moment we've got 3 questions in the Q&A form. Again, I would invite people to ask your questions now if you want to. But moving on to the first question, I think, Anna, you've potentially already answered part of this in your questions earlier on in answers, but are standard form contracts suitable for data centers?
Good question. And I'm going to be a typical lawyer now and say yes and no, sit on the fence somewhat. They are used, for example, for the construction contracts. So let's say you've got a data center in England. It wouldn't be uncommon to find that the main construction contract, the building contract, and the appointments are JCT, for example. But I think it also introduces some difficulty. And I might say you might find other standard forms, NEC, FIDIC used elsewhere. They're not really designed for data centers. those two, I would say. And I would say that all of them will require quite heavy amendment. But the bigger problem, I think, that exists is that you will often find bespoke contracts for both the development agreement and the tenancy agreement. And so that's where it becomes quite difficult to then achieve the alignment that I was talking about when dealing with Stuart's earlier questions, because often there'll be a sort of limit to the extent to which people want to deviate from a standard form. They might be used to JCT, they like the risk allocation in JCT, and so to introduce something much more bespoke or complicated can be more challenging. So I think with all of this, you have to take a step back and you have to look at the project holistically. And obviously I'm continuing for the purposes of this discussion to look at it with the owner operator hat on, in order to make sure whether the forms of contracts that are being used across the board are actually compatible, and whether or not you can achieve your commercial objectives through using it. So yes and no. I'm sorry, it's probably an irritating answer, but I think, not to say you can't use them, but you have to be a bit careful in blending lots of different contract forms on a complex project like data center.
And Peter, would that be your experience as well?
Absolutely, yeah. I mean, I'd certainly broadly agree with what Anna has said. I mean, these are projects which involve tight performance criteria in terms of uptime and power usage effectiveness, integration of complex MEP systems and tenant-specific installations. There will be harsh consequences for delay or failure. For example, SLA exposures and reputational risk. That's something Anna touched on earlier. And there'll be long operational tails where latent defects can have very high downstream impact. I don't think the standard forms, and there I'm thinking NEC, FIDIC, JCT, are particularly well adapted to that. And I mean, I'm not a transactional lawyer, but I'd certainly recommend something more bespoke for a data center. I don't think there is, to my knowledge, one that exists in the market that's a standard form data center specific type contract. So yeah, I would go to a proper lawyer and get it done properly.
Thanks, Peter. Moving on to another question we have, and I'll direct this one firstly to Peter. In your experience, just purely because you talked about delay, in your experience, what's the best way for owner operators, landlords to navigate delays during the construction phase?
It's a really good question, and thank you. I think it was Mr. Heil from Linklaters asked that question, so thank you for that. I mean, I think there's probably 5 things the owner operator can do, and I've touched on some of them already. One is document everything. It's not just the contractor that should be documenting. The owner operator can and should document to make sure that notices under the contract, for example, particularly those that relate to delay and disruption and extensions of time, they're issued precisely and they're issued on time. Because actually, if you don't properly and promptly issue your notice and do what the contract requires, that then can cause knock-on effects. I think the owner operator can track the program. They can have their own programming experts making sure that things are on track, and if they aren't, then understanding what accelerative measures should be taken and getting the contractor to do that promptly, because that opportunity, once lost, is lost forever. I think they should engage collaboratively. I mean, they shouldn't waive their rights, but they should resolve the drivers of delay as quickly as they can. So they should consent to resequencing and increases in resources. They should make the contractor's life as easy as possible, because that will then help the contractor to resolve delays. And if it does come to disputes, do it in parallel. Have that. I mean, the approach should be get on with the project. We dispute this area, park it for now, guys. Let's go 50-50 on the costs if cash flow is a problem, and let's resolve it down the line. Don't stop, and let's keep it going. So keep the show on the road. And finally, I think if you have any leverage like step-in rights as owner operator, the temptation is to use that. In my experience, that those are best used very sparingly, because if you use them wrong, that can be repudiatory, and you can be liable for damages as owner operator. And it can also be tempting to throw out the contractor and find a new one, but that new one will take a long time to come on stream, and it could be more expensive, and you may not be able to recover those costs from the contractor. So I think those 5 things are probably what I'd recommend. Thanks,
Peter. Anna, do you have anything to comment on that one?
I would just add that be open to being creative. So, for example, and this doesn't just apply to data centers, but there might be a liquidated damages regime in place for delays. And there's lots of things that you need to consider in terms of levying those liquidated damages and also balancing the need to complete the project. You're probably also facing damages as owner operator, down the line in terms of getting it ready for the tenant. So you might want to consider, for example, notifying your right to levy LDs, but potentially not actually levying them. If you think there's any sort of solvency issues or concerns in terms of putting the contractor in a bit of a squeeze financially. So I would just say as well, think about that, think about the overall financial sort of health of the parties, because I think a lot of the time people assume that these are all really big players. They can be, but not everybody is, and it depends on the way in which the contracts are let. So I would just say, think outside of the box sometimes in terms of how you can protect your own contractual rights without putting undue pressure on the parties who you need to finish the works.
Thanks, Anna. We've got 9 minutes left, so I'm going to take, we'll go into another question at the moment, and we've got an anonymous one here, and again, it's for Anna, really. If the owner, operator, and developer is the same entity, does this alleviate some of Anna's concerns with the owner, operator not having strong rights to recourse against the contractor and members of the professional teams?
The short answer is yes, probably, but I think there probably needs to be analysis of when it's the same entity, is it really the same entity, or is it just another company and part of the group? And then there's all sorts of complicated considerations as to the extent to which they are indeed separate or, one and the same, or whether liabilities can transfer between them. But certainly, yes, it would be helpful because you would have the rights, if assuming they are the same entity or broadly the same entity, then you would have the rights under the building contract, which is often what is limiting in terms of an owner operator facing the professional team and only having third-party rights.
Thanks. And another question for you, Peter. Why can't you flow down all the damages in a tenant agreement to a building contract? Surely a contractor will just price for what they have to comply with.
Yeah, I think that's a really interesting question. I mean, look, in theory, yes, you can do anything. It's just contracts, but in practice, probably no. And I say that for three reasons. One, unquantifiable exposure. I mean, I think a contractor is really going to struggle to fully understand the risks that the tenant is taking on because their requirements will change. It doesn't know what SLAs the tenant will commit to, and so it's not able to price that risk effectively, and it wants to have some certainty. It wants to just build stuff, put bluntly, and go on and just go on its business. In terms of control and interface as well, I mean, I think the contractors rarely have visibility or control over what the tenant's doing with its fit out. It doesn't know, like, the IT load profiles, for example, the operational commissioning. And so you can't necessarily expect the contractor to take on those risks. And it may also be uninsurable. And finally, and probably related to that point, just market norms and risk appetite. I mean, I think contractors generally want to operate to industry standard allocations of risk and what they know and what they understand. And that's the arrangements they will have with their own insurers. If they turn around and enter into a contract that essentially gives them exposure to uncapped risks, I think their insurer might turn around and say, no, that's not something we are willing to insure. So I think in practice, yes, you can do it, but in theory, yes, you can do it, but in practice, I think that's going to be really difficult.
I think more of a general question here, not specific related to data centers, but what or how is it determined whether it's a construction dispute or a technology dispute? Who identifies or how is it such identified?
I'm happy to take that one. I mean, a construction. So my practice personally is both construction and technology, and the reason for that is you're often doing the same sorts of things. You're building something to a specification, and there are defects, delays, and disruption. And that's really why in England, anyway, we have our construction code is formally called the Technology and Construction Code, the TCC, because those two things go so well together. I mean, in my experience, I'd say a construction dispute, it's things like design, workmanship, materials, delay and delivery of the physical works, whereas a technology dispute probably, I mean, there's no fixed nomenclature, but I would say it's things like software, systems integration, commissioning failures, maybe operational performance, and IT infrastructure. So it's very similar legally, and actually going to a construction barrister or construction solicitor, you'd probably get get the right result either way, because it's the same sort of specialism, even though it's a different industry. I don't know if Anna would agree with that.
Absolutely, I do.
Thank you. And Anna, do you see much appetite in the market for longer tail liability provisions, or are developers pushing back hard on that?
Well, I suppose Peter's already sort of touched on it, and I think it's the similar answer that I would give to this, which is nobody ever has an appetite for more liability. That's the starting point. And so really in contract negotiations, albeit I'm a disputes lawyer, but in contract negotiations, everybody is going to be working to try to limit and exclude liability to the extent that they can. And I completely agree with what Peter said about in theory, yes, you could back to back the contracts, but in practice, it doesn't happen. There's also some confidentiality issues that are very, particular to data centers that you have to be mindful of. But I still think that the parties could get closer. And as I said, I accept that there are certain market norms in terms of how liability is allocated and what developers and the professional construction team might be willing to take on. But I still think that there's more that can be done in terms of at least analysing risks down the line and up the line and trying to get closer one way or the other, just due to the drafting, for example, of the third-party rights notices if you're looking at the professional agreement, or if you have a separate developer under your development agreement, which goes back to my comment right at the outset about owner-operators still being quite exposed. So I think people will always push back, and I think generally in the market you're going to see more of that digging the heels in, always from a contractor entity or developer entity. But I think that there is still a lot of scope for movement in order to bring the liabilities up and down the line to be more aligned.
Thank you. I think we've got time for just one last question, and it's a little bit of a follow-up to that answer there, Anna, and it's more of a timing issue. Is the suggestion that the downstream tenancy contract to be drafted at the same time as the construction agreements, or merely to ensure that the tenancy agreement takes into account the terms of upstream agreements?
It's a good question, because the timeline is not, normally on a data center project, you will follow quite a lengthy timeline in terms of getting all of these agreements signed up and actually getting to the point at which the data center goes live. So it's not like you're sitting around and negotiating all of these things at the same time, or certainly not on all projects. So I think the key is actually just for people to have a better understanding of the risk profile of a data center project. And then when they are doing their negotiations, have a commercial objective in mind. So have a plan, rather than just negotiating in silos. Now we're doing our development agreement. Now we're doing, the construction contracts or third-party rights. And now we're doing our tenancy agreement. Understand the risk profile and have a plan, and then try to execute it. So the timeline for each project will actually be different. So you might have, more or less scope for alignment. But I think if you understand what it is that you're trying to achieve and you take that into your negotiations, then you should at least end up with the best outcome that is possible on that day or for that project.
I'd certainly agree with that. And I mean, I think the risk lies in sequencing without alignment. So you want to ensure that your construction contract has the flexibility to accommodate tenant requirements down the line, but it's going to be really difficult to do them at the same time, just because of the chronology of events here. But then you want to review the tenancy agreement in light of what the construction contract says, so that you're not imposing obligations on the landlord which you can't then enforce on the contractor. You just want to ensure alignment, essentially.
To also say, and I know we've only got 1 minute, Stuart, but sorry, just to say that these are often long-term relationships. So the same owner-operator operating with the same tenants. And that can also be a challenge, because what tends to happen is they pull the same agreement off the shelf that they've used 10 times before, dust it off, and there we go. And they don't actually think about the fact that they might be working with a completely different developer or completely different professional team. And so we mustn't get complacent or lazy in that regard. It's important to treat each project as its own project, own risk allocation and liabilities, and really pay attention every single time you're entering into these agreements.
Okay, and that brings us nicely just to be on time to finish. So all that's left for me to do is to thank both Anna and Peter for the discussions and the insights into data centers and the delays, the disputes, and the defects or damages that can occur. And again, thank you to all the attendees for your time.
Thanks very much.
Thank you.
Thank you, Stuart.
That wraps up our masterclass. Thank you all for joining us today. Special thanks to our speakers, Stuart, Anna, and Peter for their time and efforts in preparing and delivering this session. As mentioned earlier, the session was recorded and we'll be sharing a copy of the recording with you later today. Thank you once again and enjoy the rest of your day.
Thank you.